Okay, hopefully everybody can hear me. This is Phil Quirin, and it is, I think, knocking on 10:30 in the morning. So we're going to get started on our webinar. If there's any problems, I guess you'll let us know with an email or something about the presentation in terms of whether or not you can hear me clearly, whether or not it's coming through, and so on and so on. All right. The order of forms presentation is going to be as follows. We're going to start out just introducing you to the forms, what I call the forms matrix. It is a matrix. It also goes, I think, by the name of Guide to Statewide Forms, and it has a listing of all of the forms, the form number, the form title, the purpose of the form, and then realtor tips. And I think it's a good document for everybody to become familiar with. For a couple of different reasons. I think the main one is so you know exactly what forms exist and that are available for use. And then also in regards to just the purpose and the tips and so on, I think there's some good information in that matrix. The second document, which we're not going to spend time on specifically, is the new 2016 sale agreement. I will be talking about changes to the agreement in a little bit, but we just have that form available for you to review at your leisure. And then the third document is another matrix. It's a sale agreement matrix, and it does essentially the same thing. It breaks down the sale agreement with each section number, each section title, the purpose of that section, and then realtor tips. So it's again, something that I think is very, very good, not only for realtors themselves, but perhaps even for your own clients to use. So if you're listing a property, you can tell your client, here's the document that you're going to be getting in the form of an offer, and if you want to, take a look at this matrix, and it'll give you a breakdown of all of the sections that they're going to apply. All right, and then the fourth document that we're going to be talking about, which is the main one, is the forms changes, the 2016 forms changes, not only for the sale agreement, but all the other forms. And before I get started, I want to just touch on what the purpose of these forms are in general. Why do we have printed forms and so on? And I think one obvious reason is from a risk management standpoint, it gets you out of the business of drafting documents or provisions. A good example might be the seller possession after closing. It used to be that realtors just drafted it under additional provisions or something, a statement to the effect that the seller, maybe in a counter offer, was going to retain possession after closing, something like that. Well, with a form, it's far, far better for you to be using that than trying to draft the specifics of the provision that you want to use. And I think probably the last issue that I want you to keep in mind is that I believe that the forms set a standard of care, meaning that if you didn't use a form and you tried to draft a provision for which a form existed, and that drafting of the provision created a problem. There was ambiguity or something, and it caused a transaction to fail, something like that. All of a sudden, you're faced with the question about why you didn't use the form. And that's why I say I think the forms become a standard of care that you want to follow. Okay, so with that, we're going to launch into the rest of the documents here. We talked about the what I call the forms matrix. We talked about the sale agreement, and we talked about the sale agreement matrix. And so now what we're going to be focusing on for the rest of the presentation is going to be the forms revisions themselves. Since a good portion of this deals with the sale agreement, that's what we're going to do, is we're going to focus right now on the sale agreement. Good. All right. There we are. Thank you. And I think to start, you'll see at the top of the first page, there are areas in yellow, which represent the changes that were made to the sale agreement, either by way of addition or deletion. And then I have commented in red, italics, below the particular provision. And then I couldn't resist the temptation to address in gray not new material, but material that I regard from last year as being problematic, where there was confusion or there was need of clarification. So with that, let's take a look then at the sale agreement. You'll see, first of all, that under final agency acknowledgement, there were a couple of changes. They are minor changes, but they're good changes because it allows information to be provided at the outset that escrow can use as well. So we have, for example, the license number of the brokers themselves, and then the company license number as well. So we've put that in there so that that information is at the front end of the sale agreement. The other thing is, at least we tried to create a little more room because of the fact that in some instances properties are co-listed or co-sold, and so the administrative rules, this was brought to my attention, the administrative, by Richard Kaplan, I might mention, that Oregon Administrative Rule 863-015-0200 12B says that if the agency acknowledgement is not contained in the sale agreement itself, then it's got to be filled out in a separate document. And I suspect, like a lot of people, you may have been unfamiliar with that requirement. So if a property was co-listed, it might just have in the final agency acknowledgement one of the listing agents, and that would technically be a violation unless there was a separate agency acknowledgement that accompanied that for the other agent. So what we've done is create a little bit more room so that you can put all that information, both the names of the companies and the names of the brokers, in the final agency acknowledgement in those cases. And let's see, is there anything else we want to talk about right now? I think, yeah, down at the bottom of the page, which is where the black bar reads residential real estate sale agreement, you're going to see something that's a little bit different. And this is by way of explanation. The Forms Committee decided to actually rearrange the sale agreement so that the provisions are addressed more consistently with how the sales transaction rolls out. And the first casualty of that decision was the instructions and definitions section that would normally would be right below the bar of the residential real estate sale agreement text. And I had some issues with that decision, and I was concerned simply because I thought that if you were going to be reading a document, it would be a good idea to have the instructions for reading the document at the front end. But the decision was to go ahead and put the instructions and definitions later on. And so in an effort to at least alert people to that, you can see at the bottom of the first page here below the text residential real estate sale agreement, there is a statement for an explanation of the printed terms and provisions of this form regarding timing, notice, binding effect, etc., etc. Seller and buyer are encouraged to closely review section 31, definitions and instructions. So at least we are alerting people at the front end that if they want to know about the definitions and instructions first, then go to section 31. Okay? So with that, then I'm looking at the next page here, and you can see that I've got a comment here just explaining what I just explained about definitions and instructions. And then the first substantive section is on financing. And these sections now have a title. In this case, it's financing. And the subsequent sections that deal with financing are below it. So section 5.3 has got some new text in it, sections 1, 2, let's see, 1, 2, and 3, and 4. And I want to say that the reason for these changes relates to TRID, T-R-I-D, which stands for the TILA-RESPA Integrated Disclosure Rule. Some people call TILA, but that stands for the Truth in Lending Act, TILA, and that's a fairly significant part of all residential transactions is truth in lending. That's where the requirement for what was formerly known as a good faith estimate came from, is from TILA. And then RESPA, that relates to the closing statement formerly known as the HUD-1. And so this new rule, TILA-RESPA Integrated Disclosure Rules, represents an integration or a combining of both of those rules together, and this relates to back to the CFPB, the Consumer Finance Protection Bureau, which is a creature of Dodd-Frank. And so the TILA-RESPA rules, or the integrated rules, TRID, did a number of different things, much of which does not directly affect brokers themselves, but it does affect title companies, certainly, and it does affect lenders, mortgage brokers, mortgage banks, and so on. So the main thing is that some of the definitions have changed, and that's what you're going to see in section 5.3. The highlighted portion I'm going to review here. It says buyer shall submit to buyer's lender or mortgage broker a completed loan application for purchase of the property not later than blank days, etc. Okay. Now, the next sentence is what's important. It says a quote completed loan application shall include the following information. We identify six different topics: the buyer's name, the buyer's incomes, the buyer's social security number or numbers, the property address, an estimate of the value of the property, and the loan amount sought. Okay, so a loan, by definition then, a completed loan application has to include those 6 items. Why is that important? It's important because we want to make sure, we being, shall we say, the seller, that we know that the buyer is going to go out and submit a completed loan application, because under TRID, what that does, it triggers an obligation on the part of the mortgage broker or the lender to actually submit what was formerly known as a good faith estimate and now is called the loan estimate. Don't ask me why they took the words good faith out of it. Maybe that was, well, I won't get into the history of it because I wasn't participating in those kind of decisions, but you'll see that the loan estimate is supposed to be still in good faith. They just don't call it a good faith estimate. They call it a loan estimate. And under TRID, when a completed application is submitted, then the lender's obligation or the mortgage broker is to submit a loan estimate within 3 business days. So that's important then, because if the loan application does not include all 6 of those, then the lender is not required to give the loan estimate within the 3 business days. They could give it 4, 5, 6, or 7, or whatever. And that's problematic for sellers, because sellers want to know that the transaction, the wheels are starting, and that the transaction is gearing up, and that can only happen, technically happen, with a completed loan application. It is my understanding that some mortgages or mortgage brokers discourage a completed loan application, and that for that kind of a discussion or decision, you'd want to talk to your own mortgage banker or mortgage broker. But if it's a completed loan application, then that triggers the duty to deliver the loan estimate, and then if the buyer agrees with the terms of that loan estimate, then they are required within 10 business days to notify the mortgage banker, mortgage broker of their intent to proceed. And that's what Section 3 deals with. So Section 3 assumes that it's a completed loan application, and then the mortgage broker will submit the loan estimate, and then if the buyer is going to proceed, they've got to give that 10 business day response. And then you'll see in number 4, upon request of seller or seller's licensee, buyer shall promptly provide the date of buyer's signed notice to the lender or mortgage broker of buyer's written intent to proceed with the loan. Okay? So what it does is it allows the listing agent to track the status of the loan process much better. Now you'll see in number 7, it's gray. I highlighted that in gray because even though it's not new, I have experienced at least a couple of different discussions with mortgage brokers who indicated that they didn't actually realize that they had to share information with the listing licensee. So number 7 says buyer authorizes buyer's lender or mortgage broker to provide non-confidential information to listing and selling licensees regarding buyer's loan application status. And so it's, if you have a mortgage, if you call as a listing agent the mortgage broker and you ask about the status, and they tell you that they're not going to share the status, you can direct them to Section 7 that says that it's already been authorized by the buyer. We're only talking about non-confidential information. And then the text here and the comment is pretty much everything that I've just said. So I'm going to move on then to Section 7. It's the seller carried financing section. Oh, and by the way, under resources, you can see we've got several different resources that do address TRID. And so if you want, if you're a glutton for punishment and you want more information on TRID, we've set those out. So Section 7, seller carried financing. I'm going to assume that folks in Central Oregon are doing at least some seller carried financing. And so we're going to go through this with some detail. Seller carried financing, for example, that'd be a land sale contract, deed of trust, an option agreement, you know, like with an option to purchase, a rent-to-own transaction, any kind of a situation, regardless of how it's named, that contemplates that there will be the seller will carry back financing. And by that I mean for some or all of the purchase price, and that the buyer will be making periodic installment payments to the seller themselves. There is no third-party institutional lender involved. And that is, by definition, under the sale agreement, a seller-carried transaction. And that's, again, where federal law has thrown a monkey wrench into these otherwise relatively limited number of transactions. You'll recall that during the Great Recession, that the big institutional lenders were uniformly criticized because of some of the financing provisions that they had and the application process and the lending of money ostensibly to people that were not qualified. So what ended up happening, this is under Dodd-Frank 2010 law that they're still trying to sort out with administrative rules because they haven't adopted all the rules yet. It's only been 5 years. And so under Dodd-Frank and some other federal laws, essentially there was a law that said that if you offer or negotiate a loan, that you have to be a mortgage, you have to be licensed as a mortgage loan originator. And the definition of a loan has been broadened to the point where now the federal law at least suggests, whether it mandates it or not, at least it suggests, and it's been so interpreted, to apply not only to Bank of America and all the big boys on Wall Street, but also it's been interpreted to apply to little mom and pop sale transactions where they're carrying back the paper. This is what I call collateral damage, because I don't think mom and pop were responsible for bringing down the financial institutions. I think it was the big banks and not mom and pop. Regardless, they've been caught up in this, and so what we have to concern ourselves with is whether or not on these seller-carried transactions, whether or not the seller in engaging in this transaction is subject to the MLO licensing law, the mortgage loan origination law, that says that you can't do it unless you have a license. Well, Oregon exempts the following individuals from this, and this is a good thing. The Oregon exemptions are better than the federal. Number one, those who offer, negotiate terms of a residential mortgage loan on behalf of their spouse, child, sibling, parent, grandparent, grandchild, or a relative in a similar relationship created by law, marriage, or adoption. And that's a huge exemption, by the way, because I mean, by and large, that's what these transactions are, is typically a seller is doing it for themselves or they're doing it on behalf of a relative. And if that is a situation, then the MLO law does not apply. That is to say, the seller is exempted and does not have to get a license. Secondly, another large exemption is those who sell their primary residence. And the primary residence definition doesn't mean that they have to be living in it now. If they ever lived in that house, then it qualifies as an exemption from the MLO licensing law. And then thirdly, individuals that sell up to 3 non-primary residences during any 12-month period. And those, if that applies, they sell up to 3, not more than 3, but up to 3 within a 12-month period, then they are also exempted. So you can see that these statewide exemptions are generally going to carve out a safe harbor for probably 95% of the transactions. But in order to be safe and make sure that our form is compliant with the state and federal law, we have to vet all of this. We have to vet this through through a series of provisions that are now found in a separate addendum, and I'll be talking about that. It's a seller carry addendum. So if it's a seller carry transaction and one or more of those exemptions apply, then it's okay for the buyer and seller to use that seller carried exemption. That is to say, they don't have to worry about the seller going out and getting a mortgage loan originator to handle the transaction. Okay, and the seller carried addendum is OREA Form 033. We'll be talking about that later. If the transaction doesn't meet those exemptions, however, then the seller should be getting the assistance of either an MLO or another person who is exempted under the MLO licensing law, for example, an attorney. Okay, looking at the next page, let's see here. The contingencies, seller representations, the contingencies. Now, this relates to section 15.2 under FIRPTA. You'll recall probably that the FIRPTA section of the sale agreement was inordinately long. And the reason in large part that it was long was because even though most of you have probably not even had an occasion to have a FIRPTA transaction, the consequences of ignoring FIRPTA are huge, because what FIRPTA says is that if you are a foreign person, and that's defined as a non-resident alien individual, foreign corporation, former partnership, foreign trust, or a foreign estate, if any of those entities or individuals sell a property in the United States, then they could be subject to FIRPTA. And if they're subject to FIRPTA, then what the law says is that there's got to be a 10% withholding of the gross sales price, essentially a presumed tax. And just recently, it appears that that 10% in some instances has been changed to 15%. And so if a foreign person subject to FIRPTA sells the property in the United States and that 10% withholding does not occur, you know who gets tagged for it? The buyer. So, because the buyer's presumably still in the country. It's the seller who is back in, let's say, their other country and beyond the reach of the IRS. So you can see that the consequences of ignoring, inadvertently or otherwise, ignoring FIRPTA can be huge. So the main thing to know about this is that there's a major exemption that even if the person is a foreign person, if the property is not more than $300,000 and it's going to be occupied as a residence by a buyer who is an individual or a member of his or her family for at least 50% of the number of days it is used by that person during the first 2 12-month periods, then it's going to be exempted. Now, don't ask me why it says the first 2 12-month periods. I mean, it would seem to me, maybe this is government speak, but it would seem to me to be easier just to say used by any person during the following 24 months. So this is government speak, and that is the exemption. And if that exemption applies, even if the person is a foreign person, then FIRPTA is not going to apply. So what we did is we shortened down section 15.2 under the FIRPTA discussion and pulled much of the text out and added an addendum, which I'll be talking about later, and that's OREF Form 092. So the sale agreement itself is shorter because we have an addendum that takes up the slack. Now, for those of you that are thinking that this is just a lot of hot air, let me tell you that most people would say today that during the last 5 years of the recession, that there have been an influx of foreign investment in real estate. And if there are foreign persons that are owning real estate today, at some point they're going to be selling. So you want to make sure that that issue gets vetted, and sooner the better. And I know that the RMLS has inserted a provision in their listing agreement that has a provision in regards to whether or not the seller is or is not a foreign person. And for those MLSs out there that don't have that provision, let me suggest they talk to their legal counsel about having one, because the best point to be vetting that issue is at the inception. You don't want to find out that the person is a foreign person and subject to FIRPTA in closing or right before closing. And the other thing that's important to know a file away is whether you know it or not, is that if you go in to a closing and actually read the documents that escrow puts in front of you, you will see there is a provision, a separate document that says that the title company is released from any and all liability on account of FIRPTA. So if it is a FIRPTA transaction and it's subject to FIRPTA, you want to make sure that the title company knows about it so that you're not releasing them from the obligation to assist in the FIRPTA law that has to do with taking that 10 or 15% of the gross sale price and sending it to the IRS within 20 days of closing. Okay, so we're going to move on to escrow, closing, escrow. Again, this is where TRID kicks in. 27.2 refers to the closing disclosure. And the closing disclosure was formerly known as the HUD-1, And for anybody that's had a transaction in the last 2 or 3 months where the loan application was submitted after October 3, which is when TRID became law, for you folks, you probably have seen a little bit different language, and I don't know if there's been delays. There's some talk that TRID was causing delays, but it's slightly different. And for your purposes, you should be aware that the HUD-1 is no longer a HUD-1. It's now called the closing disclosure. So what we have in section 27.2 is a statement that pursuant to TRID, that the buyer and seller will each receive a federally required document called a closing disclosure, which among other things summarizes each party's closing costs. We go on to say that TRID requires that the closing disclosure must be received by a residential loan borrower at least 3 business days prior to consummation of the transaction. And this is all new. If the what was formerly known as the HUD-1, if the closing disclosure is delivered within 3 business days of the closing date, then the closing date has to be pushed off. So that's a big deal. There's a lot of hand-wringing about that prior to October 3, but the law in regards to when a TRID-driven change would require the closing date to be pushed off is very, very limited. I won't get into the provisions, but they are very, very limited and fairly remote. Not in all cases, but fairly remote. If the situation should present itself, though, the problem is that in our sale agreement we do not have a safety net that says that if there's a TRID-driven change that requires a reissuance of the closing disclosure, that the closing date will be extended. We don't have that provision, and we discussed that at the Forms Committee level, and the decision was not to push that out. For some of the old timers like myself, you may remember that years ago there was a provision that said that the closing date is X, but then it said it will be extended by, I think, not more than X number of business days. I think it was 3. If the closing documents can't be prepared in time, something like that. Well, obviously, what that was an effort to address the possibility that the lender or the escrow company wasn't as efficient as it should have been. And so the problem that creates is when you tell somebody that they can have some extra time, they'll take it. And so I think the consensus was at the time that we're going to take this safety net out, so everybody is focused on the fact that it has to close by the quote closing date, and if it doesn't, the deal is dead, or at least it can be terminated. Parties don't have to agree that it's dead, but they can. And one party or the other can say, okay, fine, we missed the closing date, the deal is dead. All right, so in any event, what we've got here is a provision that addresses, it's more advisory than anything else, that says that if the closing disclosure is delivered within the 3 business days that the prior to consummation, that it's going to have to push out that closing date. Now, the word consummation is a TRID term. It is not used in the sense. Well, let me state it another way. Consummation is defined by the TRID folks as being the date that the loan becomes binding. And if you get into, if you look at the rules and the explanations by the CFPB, they'll say that the date of consummation could be the same as the closing date, but isn't necessarily. That is not consistent with how transactions are treated in Oregon and a lot of other states. That is to say, a closing date is a closing date. It's the date that the loan is funded and the documents are recorded, and that's what we regard as the closing date. But if you went in under TRID, if you went in and signed a promissory note today, even though it wasn't funded and it wasn't recorded under TRID, that would be the consummation, because now in theory the loan became binding. There's a lot of disagreement and discussion about this, and what the CFPB did on this rather technical issue is they punted, and they said, well, what everybody should do is you should determine based upon your own state law when consummation is. Well, that's fine, but in most states, such as Oregon, we do not have a law that says consummation is on such and such a date when the following events occur. And as far as I know, there has been no effort at the state level legislatively. See, the DCBS and the DFCS, I think the DFCS, Department of Finance and Business Security, something like that. There's been no effort on the state level to actually address the word consummation and give it some definition in the financing context. And so right now, there's an open question. And so I don't think it's a big issue, but it's something that you're going to see, and that's why we use the word consummation here. That TRID requires that the closing disclosure must be received prior to, quote, consummation. And then what we've said is, which in most cases in Oregon will be the date on which the buyer signs the loan documents. Under certain circumstances, a change to the closing disclosure late in the transaction could result in a delay in closing to comply with the 3 business day rule. Such a delay beyond the closing deadline could result in termination of the transaction unless seller and buyer mutually agree to extend it. And I've heard of situations where some proactive brokers are writing in provisions in an addendum or something in advance that said that if there's a TRID-driven delay in the closing, that it will be extended. I'm going to leave that to company policy. I'm not convinced it's wise, but it's something that some brokers, I understand, are doing. And then 27.3, notice regarding title insurance costs, is another issue with what I regard as a disconnect created by TRID. And you can talk to your own title company and escrow officer about this because it's beyond my skill set. But what it essentially is saying, this notice 27.3, is that TRID requires a disclosure of the title insurance different than the way we do it here in Oregon. And so if you went to your loan estimate and you looked at the loan estimate as to what the cost of the title insurance was and a lender's policy was, and then you compared that, the loan estimate, to the actual closing disclosure statement, those figures would not jive. And that's a result of TRID again. And so what we're telling people here in 27.3 is talk to your escrow company prior to closing so that you can fully understand that in fact the costs of title insurance are in fact what they were estimated to be in the closing disclosure. It's my understanding, I hope I'm right, that what title companies are doing is they're going ahead and delivering the closing disclosure, even though it's got it confuses the issue on the cost of the title insurance, and then they issue their own little closing disclosure that corrects or explains or shows the true cost of the title insurance that is consistent with a loan estimate. Okay. And you'll notice that I say under the comment, these 2 provisions are informational only. And why are we doing this? I mean, you could say, well, what difference is it? Why are we trying to explain to everybody all this TRID stuff? And the answer is because at some point, whether you go to closing or not with your client, somebody's going to say, a sharp-eyed person is going to say, well, wait a minute, I don't understand. These figures are not consistent. So at least we have a heads up in sections 27.2 and 27.3 so that it gets you off the hook of trying to explain something that most people don't understand and can't explain. Okay? Let's see. Oh, and you'll see down at resources for a pretty good explanation by the American Land Title Association. That's at the blog by ALTA, ALTA, and they just go to town on TRID on this, on the DCBS. It's not the DCBS, CFPB, the Consumer Finance Protection Bureau, and I agree. I am troubled by the fact that they would intentionally create a provision that they know is going to cause more confusion, particularly when they have this mantra, know before you owe, and yet they're confusing people before they close. So moving down to seller possession before or after closing, section 30. The only change here is that we always had a provision in regards to seller possession after closing, but we also have a situation where if the buyer wanted to possess before closing, that would be that is also then addressed too. So we've got two separate forms: the agreement to occupy before closing, ORF 053, and OREF 054, the agreement to occupy after closing. If any of you, by the way, have a question, I assume there's a protocol for doing this. Okay, John, it's my understanding John would enter it. So if you have an issue, please let us know as I'm going through this, so that I can address it as we're covering the topic. So right now, I am looking at section 30. Let's see, not section 30. We just covered that under the definitions and explanations. So buried in the middle of the sale agreement is what was formerly section 1, definitions and instructions. And you'll see that I have in gray section number 6, gray being highlighted that way because I want to talk about it, but it's not new. It was last couple of years, I think, that this provision came into existence. And it says, unless seller and buyer expressly provide otherwise, the phrase signed and accepted in the printed text of the sale agreement or any addendum or counteroffer shall mean the date and time that either the seller and or buyer has A, signed their acceptance of the agreement received from the other party or their licensee, and they've transmitted it to the sending party or their licensee, either manually or electronically. Now, what this refers to is something that has been in the law for forever, and that is that under contract law, in order to have a contract become binding, sometimes known as a meeting the minds, in order to have it binding, it's got to be signed and it's got to be transmitted back to, signed by the offeree, in this case the seller, and transmitted back to the offeror, in this case the buyer. So for example, and that's important for understanding when it becomes binding, because when it becomes binding, then the offeror, the person making the offer, no longer has the power to withdraw the offer. So for example, when a buyer makes an offer and gives it to the seller, if the seller is looking at it in the evening time, reviews it, and is satisfied with it, and is going to sign it and send it back in the morning, let's say they sign it tonight, but they don't send it back tonight, they don't transmit it, then in the morning the seller gets up and decides, no, I don't think I want to do this. So they scratch out their name and they transmit it back with a rejection. Okay, that is an effective termination or rejection of that offer. That's effective. Or to put it another way, if in order for this to be binding on the seller must have signed it and transmitted it. And once it's transmitted, I didn't say received, I said transmitted, then the transaction has now become binding. So if the seller in the morning decides, yes, I do want to do this, and they sign it, and they transmit it back to the buyer or the buyer's agent, they transmit it, all of a sudden, bang, it's become binding. In other words, even though the buyer doesn't know that their offer has been accepted, If the buyer attempts to withdraw their offer and it's already been transmitted, the buyer cannot do that, and it's become binding on the buyer because the seller transmitted. Now I say transmit, I didn't say receive, which means that the minute that the seller or the listing agent in the transmission process hits send, let's say it's a PDF on a email, the minute they hit send, then all of a sudden, bang, that is when the transactions become binding. Okay, and that's why we have put gray on this, is so to make sure that people understand this. This is not a new rule. Back in my day, when I went to law school, we had no discussions about transmission by electronic means, but we had what was called the mailbox rule. And so in that case, when the seller signed the offer that they had received and they deposited it in the mail, that was the same as transmission, because it was deemed to be essentially irrevocable. And so the minute that it's dropped in the mailbox meant that that's when it became binding on everybody. Now today, it's when you push the electronic button, but it's the same concept. It isn't sufficient to sign. It's got to be signed and transmitted. And this has been the law forever and ever and ever. Okay. And let's see. I guess I've got a resource here. It's one of the resources is on my own website, q-law.com, and which I talk about offers and counteroffers and revocations and address all of that. So then number 7, which is new, says the sending of a signed acceptance of the agreement via electronic transmission from one party or the licensee to the other shall have the same effect as manual delivery. So it's just to clarify that the electronic transmission is the same as if I'm standing in front of you and handing it to you. It's the same thing. If the parties intend to use any other method of transmitting a signed offer or acceptance, such as regular mail, certified mail, or overnight delivery, they should so specify at Section 20 of the sale agreement. And the reason that this was put in here is primarily because 99 times out of 100, at least in local transactions, we do not put things in the mail in order to affect the transmission. We use email, and so this is just a complete reversal of the way business was conducted in the past. And I wanted to make it clear that if you're going to use the mail as a means of transmission, then you got to so specify either by an additional provision section or something, so that everybody realizes that they're looking at the mail. And when that becomes relevant, of course, is when you're dealing with people on opposite ends of the coast or in foreign countries and things like that, where for some reason or another electronic transmission doesn't work. So if that's the case, you want to be sensitive to the use of the mails or the FedEx, UPS, or whatever, so that everybody is dealing with the same medium. I'm looking at my comment here to see if there's anything else to add. Yeah, I think we're okay. So I'm going to move on. In Section 11, this is new, and it says accepting only the lead-based paint contingency period identified in Section 11. With that exception, unless a different time is specified in the agreement, all deadlines for performance, however designated, that are measured in business or calendar days shall terminate as of 5 p.m. on the last day of the deadline, however designated. I actually think I probably should have kept that in black because it's not a new provision, but I put it in gray because it's not new, but it's one that's, again, it's caused some consternation because we always had midnight of the final day as being the operative date. And if you still like midnight because you're a night owl, fine, then, or your client is that, you want to make sure that it becomes clear in the additional provisions or somewhere that you're not going to use the 5 o'clock rule. It's going to be midnight. And with working folks, perhaps who need to, for example, come home and look at something in the evening, you want to make sure that everybody knows if it's going to be later than 5 o'clock as a deadline, that it's specifically called out. All right, dispute resolution. The dispute resolution section of the sale agreement has not substantively been changed, but it has been condensed. And the reason is because we were wasting an awful lot of space to identify the difference between disputes between party versus party and party versus real estate licensee. And so rather than have two separate distinct sections, which just made it more confusing, what we've done is to try to explain the dispute resolution process by combining both of them together, both disputes against the licensee and disputes between the parties themselves. In Section 36, by and large, well, it's all substantively the same, but I'm going to go through it anyway because I have a feeling that a lot of people don't really focus on this because they don't anticipate there's going to be a problem, and when there is, then they end up having to read dispute resolution provisions for the first time. What the effort of this entire section is, or Section 36 through 37.4, is to remove disputes out of litigation, meaning court filings where you file in court, and put it into some form of alternative dispute resolution process. And so we define claims very, very broadly. A claim is any kind of a dispute between the seller and the buyer or with the licensee, with only a few exceptions, such as, for example, an eviction process. If you had a seller retaining possession after closing and refused to vacate, you don't have to go to arbitration in order to get them out. You can go directly through the eviction court in the local county. So other than those type of situations or a mortgage foreclosure or something like that, by and large, almost everything has to go through this alternative dispute resolution section. And 37.1 calls out those specific exclusions. So if it relates to a mortgage or trust deed, that's carved out. The FED, forcible entry and detainer, is carved out. And if it's something that's subject to the NAR dispute resolution process, then that's how it's going to, our professional ethics and arbitration, and that's how it's going to be resolved. If it relates to a commission or a fee, then the MLS listing agreement will determine the form of dispute resolution. And then there's one other major exception that is probably not one that most of you are familiar with, but if a court or a party needs to have what's called provisional process, which is called like a temporary restraining order or something like that, they can still use the courts for that. And that would be a rarity, but that would be the fifth exception. So the takeaway here is, number one, if the amount in dispute relates to money and it's $10,000 or less, there is no alternative. It must be brought in small claims court. You're not going to have a mediation or arbitration for $10,000 or less. And if the dispute is over $10,000, let's say it's $10,500, I would probably recommend that the party that wants to file should just file in small claims for $10,000. Normally in small claims court, if the amount is above, I think it's $250, then the defendant can go ahead and force removal into court. We are excluding that option here by saying that notwithstanding ORS 46.455 sub 3, which gives that right to remove, neither buyer nor seller shall have a right to request a jury trial and so remove the matter from small claims department of circuit court. A judgment in a small claims court is final and binding, and there is no right to appeal. And believe me, that has eliminated a whole lot. That $10,000 carve-out has eliminated a whole lot of dispute resolution arguments, and just put it in the small claims court. And since small claims courts typically have a mediator available for the parties to go out in the hallway and resolve the matter if they can, we felt that the fact that there wasn't a specific mediation provision for a $10,000 dispute was not that big of a deal, because there is a right to mediate out in the hallway of the small claims court. If the claim is over $10,000, then yes, there is a right to bring the matter into arbitration. But at the time you file for arbitration, or before you file for arbitration, it is required that the seller or the buyer offer or agree to mediate first. Okay? And the reason that that's important is because if a party just jumps the gun and files for arbitration but doesn't offer to mediate, and then they just leapfrog over mediation and they go to arbitration and they win, they cannot get prevailing attorney fees. That's the disincentive for ignoring the mediation system. Is if you want to do it, then you're not going to get prevailing attorney fees if you win. Okay, and if it's a mediation involving licensees and firms, and this is probably going to change, 37.4, I think it's going to change this next year, because essentially what it says right now is that claims that include licensees or firms may be resolved through the dispute resolution process. However, it's not mandatory that the licensee or firm participate. And as I say, I think this is going to change, where they will be required. All right, I'm looking now under the bar entitled Signature Instructions, and this was another area where this is section 38 below in gray, where it says before the gray, it says this offer shall automatically expire on blank date and time if not accepted. Well, what happened several years ago was that an offer had expired and the seller went ahead and accepted it anyway and sent it back, and the buyer was fine with that. But for some reason, the real estate agency didn't like that. And they felt that one or both of the licensees were negligent in allowing that to occur. Now that interpretation is beyond me. I don't see why parties can't agree to extend a date, but that didn't sit well with the agency. So we had to deal with some of these nuances, and so we have a statement here that says the buyer may withdraw this offer before the offer deadline at any time prior to seller's transmission of a signed acceptance, which basically before it becomes binding. If seller accepts this offer after the offer deadline, it shall not be binding upon buyer unless accepted by buyer in writing within blank business days, 2 if not filled in, after the date of seller's acceptance by so indicating in section 41. So what this is saying is that, and we're trying to create a protocol so that it can't be said that the realtors did anything wrong by allowing it to happen. We're trying to create a protocol that says basically that even though the seller slept on his rights, it had already expired, he still wanted the deal, and the buyer was agreeable to that. That is to say, to extending the offer deadline. And so we're saying that it's not binding on the seller if there's a late acceptance, unless the buyer accepts within blank business days after the seller's acceptance by so indicating in section 41. So let's go to 41, and that's the buyer's acknowledgement. Again, there's a portion in gray. It says buyer acknowledges receipt of a copy of seller's written response to this agreement. If seller's response is an acceptance of buyer's offer that occurred after the offer deadline identified in section 38, then buyer, and you select only one, the buyer agrees or does not agree to be bound thereby. The failure to check either box shall constitute rejection of seller's acceptance after the offer deadline. Okay? So if the buyer, and this is new, it says if the buyer checks the box agreeing to be bound by seller's late acceptance occurring after the deadline, then this sale agreement shall become binding on all parties only when the buyer has signed by law and transmitted it. Because you see, because of this late acceptance, now all of a sudden the ball has shifted to the buyer to say, yeah, I'm okay with that late acceptance, but you got to tell the seller something. That is to say, if you didn't say anything to the seller, then the seller wouldn't know whether or not this transaction had been resurrected after the belated acceptance. And so we're saying now that the buyer has got to not only indicate that they're willing to accept the belated acceptance, but also to transmit that back. So we now have a binding contract. And then in yellow below the signature, it says, if buyer has checked the box and signed where indicated in this section 41, agreeing to be bound by the seller's late acceptance, buyer or buyer's licensee must complete the information below and thereafter promptly transmit this completed agreement to seller or seller's licensee. And so then we have this gray area. It says, enter the date, time, and method. Now that's the way that the text has read for a couple of years, I think. Enter the date, time, and method. What has changed is the text above in yellow to clarify or make it more clear that by entering the date, time, and method of the seller's acceptance and then identifying the seller and then transmitting it, that at that moment in time, now the transaction has become binding. It doesn't become binding until the buyer accepts and transmits their acceptance of the seller's late acceptance. Okay. The next document, and I mentioned this earlier, this is an addendum, and it's the FIRPTA addendum. And I agree that most of you have probably not run into a FIRPTA transaction, and it may be that you may never, but it's becoming more and more likely because of the amount of foreign ownership of residential property that you will run into it. And like I said, it would be good to vet this issue by the listing agreement, if possible, by identifying whether or not the seller is a foreign person. And I'm not sure what the MLSs are doing, but as I said, our MLS does vet it. So at least the parties at that time, the potential buyers, are aware. Because remember, like I said before, it's the buyers that got this horrific exposure if FIRPTA gets ignored, because it's then going to be on their dime. And you can be sure that if a buyer gets tagged for a FIRPTA withholding for the seller, that buyer is going to say, why didn't my real estate agent tell me about this? And the real estate agent would probably say, well, why didn't the listing agent tell me about that? And so you can see that if there's a claim between the parties, that the realtors are not far off. And of course, the seller is probably on an airplane back to their other country outside the jurisdictional release of the IRS. Okay, so this addendum is completely new. And it says much of what I've talked about before, so I won't necessarily repeat it, but it talks about the exemptions from FIRPTA, the $300,000 and personal residence by the buyer for at least 2 years, 50% of the time. And then we have a provision that says, in such case, if it's exempt from FIRPTA, in such case, upon written request of the seller, buyer agrees to sign a declaration of such intent. Now, the reason we have that in there is because, in theory, if FIRPTA didn't apply because it's $300,000 and you have this occupancy rule, then what happens if the buyer doesn't occupy as they say? And therein lies the problem. So in such case, upon written request of seller, buyer agrees to sign a declaration of such intent on or before the closing date. If for any reason following seller's said written request to sign the declaration, buyer fails to do so on or before closing, then the seller may terminate this transaction. And that what we're trying to do is to vet the issue that in fact it's exempt not only because it's $300,000 or less, but because the buyer is going to be personally occupying it, or a relative is going to be personally occupying it for this period of time. And otherwise, if the buyer didn't personally occupy, then FIRPTA would apply, and the seller would have liability. Okay. The second alternative is the seller is a foreign person and they're not exempt, and we address that situation. So we got one, the seller is a foreign person, but they're exempt because of the nature of the transaction. Secondly, the seller is a foreign person not exempt, and then thirdly, the seller is not a foreign person. So we address all of those alternatives, and I'm not going to go through each of them here, but I just want you to be aware that this is a good approach to vetting the whole issue if you're dealing with a foreign person. The next items that we're going to be talking about are the seller carried forms. Like I said before, we've created a new suite of forms, and they are referenced in the sale agreement itself. And the first form, of course, is an advisory itself. It's just informational, and it's provided for the parties to understand what the nature of the transaction is about. And it also makes it clear that the realtors should not be a source of an informational source for providing answers to technical questions and so on. So basically, it's a risk management tool for realtors, so that it makes it clear that they're not going to be answering technical questions. They can act as a scrivener, and that's the main thing that they're going to be doing, but they're not going to be talking to the seller or the buyer, making recommendations about what kind of legal documents to use or what kind of terms to be putting in the transaction. The most important of all of these documents, in my opinion, is the addendum to the seller carried transaction. And what it does is it attempts to vet this issue as to whether or not the seller is a mortgage loan originator, i.e. whether or not they do or do not fall into the exemptions under state and federal law. If they fall under the exemptions, then they can safely go ahead and engage in a seller carried transaction without worrying about whether or not they're in violation of the mortgage licensing law. And so that's what this entire suite of forms is all about, and the addendum being the main one, because it's going to be a part of the sale agreement itself, and it doesn't deal with the standard, like when there's a closing date and things like that. All it deals with is the vetting process of the seller, making sure that because of the seller's history of how many seller carried transactions they've engaged in and so on, and the nature of the type of the property, 1 to 4 family dwelling, if all of these are addressed and they're addressed affirmatively, then the seller is going to be exempt, and the realtors are not going to be in exposure for being accused of participating with the seller and not vetting the issues to whether or not they're exempted under the mortgage licensing law. So I have gone through in this handout. I've set up the entire text of the seller carried addendum, but I've also talked about the purpose of each one, and you can see that most of the purposes are risk management. So in section 1 it says the seller and the buyer understand and acknowledge, and we basically go through all the language that says that it's that the realtors are not permitted to offer or negotiate the terms, that the seller understands that if they need professional assistance they should secure it, and so on. So that's the risk management component. And then we also advise in section 2 that they should closely review the advisory. And then section 3 and section 4 are certifications. And these are the two major certifications that, if they are successfully answered, will certify that the seller is not subject to the mortgage licensing laws, is not subject to a requirement of having a mortgage loan originator. So we say on the section 3, during the preceding calendar year, seller did not enter into more than 5 seller carried transactions. that during the preceding seller 12 months, seller did not enter into more than one seller-carried transaction that involved terms making it a high-cost mortgage. Now, just as an aside, if you look at the advisory, it defines what a high-cost mortgage is. And as I'm going to say later, but I'll say it now, if your seller thinks that they want to put the screws to the buyer with onerous terms or something like that, this is not the place to be doing it in a seller-carried transaction. Because it's a high-price mortgage, then that triggers the MLO law. So in any event, that's what these sections 3 and 4 are trying to define what the what the nature of the transaction is, and if they're all properly answered, then it's okay for the seller to proceed. And then we have a place for the seller to sign or initial. And then section 4 does the same thing. The seller must be a natural person, and we go through all of the requirements that the seller must meet. And if they do, then they certify, yes, I meet all of these requirements. And having satisfied sections 3 and 4, then they're exempt from the mortgage licensing law. And then section 5, just as a confirmation by the buyer as the intent, they're going to occupy the property or they're going to use it as a business for business purposes, and that's informational only. So that first half of the addendum then is the document that vets the issue as to whether or not it's exempted from the MLO law, and then sections, the rest of the document deal with the financing. And you'll see that I've highlighted in blue those financing terms. Deals with the interest rate, the amortization, the balance of the purchase price, monthly payments, when the first installment is due, a late charge, and so on. And then the other terms, these are non-financing terms, but there are other important terms, allowing the right of prepayment, restricting the right of assignment, things like that. So all of these things are addressed in the following sections of the addendum. Such as escrow, setting up a collection escrow, and things like that. If it's a contract of sale, then you're going to want to have a deed held in escrow. And then the final payment is going to be a balloon or not a balloon. And some of you, if somebody thinks that you can't do a balloon payment, that the law prohibits it, I would say that you are right under the federal law, the truth in lending law, but not under state law. And the vetting process that we just went through exempts the federal law, the application of the federal law. So if in fact under state law you can have a balloon payment, you cannot under federal law, but the federal law wouldn't apply if all the questions are properly answered in that first half of the addendum. And then on the insurance and so on, we cover all of those, both the insurance, the taxes, withholding, and so on. So those address all of the main aspects of a seller-carried transaction. And then section 10 deals with how's it going to be secured, with a trust deed, or is it going to be secured with a contract of sale? And I want to caution realtors to make sure that they don't make that decision or make recommendations, because there's a lot of variances about that based upon locale, and some attorneys may have different views of it. The promissory note is the document that accompanies the deed of trust, and I've covered cover in the materials what they are used for. The deed of trust is recorded. The promissory note is not recorded, and these seller-carried transactions are only used in should be only used in situations where the contract of sale or the deed of trust is going to be recorded in the first position. And then section 7 of the handout, I'm dealing with the contract of sale, and I think most of you know what a contract of sale is. It does differ from a deed of trust in certain respects, and you want to make sure that your client, whether it's a seller or buyer, has legal advice on this, because some attorneys have certain beliefs as to which is best for whom. So you want to make sure your client gets legal assistance on that. And then we have a memorandum of contract to record that is just a bare bones one-page document so that it gets recorded on the public record. Now, on number 9, I talk about a decision tree, and unfortunately it's not included, but it's something you can get on ORF Online, and it's a one-page flowchart that if you look at it, you will see that that's much simpler, by the way, than perhaps I've explained it. It allows you to look at it and determine whether or not the MLO law applies, and that's on ORF Online, and it's called Decision Flowchart. The notice pursuant to the short sale addendum is just that. It's a notification by the seller to the buyer that the loan has been approved. And once this is filled out, then all of a sudden it now makes the transaction binding, because you'll remember back in the days when short sales were so frequent, that a short sale was contingent upon upon lender's approval. Okay, the contingent right of purchase has always existed, but there is one additional provision that's been added. Right now, the contingent right of purchase is only to be used in situations where the seller is selling their own property, and where the buyer is selling their property, and that's a contingency of the transaction. And the form itself has been in existence for some time, but there's been a new provision that's been added, and frankly, we don't expect that many people are going to be doing it. But it allows the buyer to agree to remove the contingency only as it relates to the buyer's sale of the property, but not as it relates to the closing of the transaction. And that's alternative 3, and it's been added, and it's new. So you want to make sure that you understand this. And if anybody has any issues about it, I'd like to hear about it, because this is a fairly significant change of the approach. And I would like to make a correction here in the contingent right to purchase section under the discussion. Let's see, where is it? Where's my discussion? Oh, it's down in the comment section. There's a place at which I stated that the transaction would not go pending, and that's an incorrect statement. If a buyer, put it another way, if the buyer removes one contingency, i.e., the sale of their home, but not the closing, it still goes pending. And under the comment section, I had incorrectly stated otherwise. So in any event, then if you look at the next page, I have set out step by step the protocol as to how this document should be used, and it's something that for those of you that are using it for the first time, you may want to follow the protocol so that you understand exactly how it's supposed to work, and you can go over that with your client. The buyer's notice of waiver / removal of the contingency is new, and that's a notice where the buyer is saying, I removed the contingency, and what it does is it addresses exactly which contingency is being removed. If you look at number 2, it says buyer's signature below, buyer gives notice that the entire contingency is expressly waived, or the contingency is partially waived. It's the sale but not the closing that's waived. And so this notice, 83083A, goes hand in hand with section 83, and it should be used in that manner. Now, there's a document that's been in existence for some time called Blank Hour Contingency Agreement. I'm looking at number 13 here. It's 052. Historically, some realtors were using this when you had a contingency that was based upon the buyer's sale of the property, and so they were using that for a transaction where the offer was subject to the sale of buyer's property. That's not what it's intended to be used for anymore, and it's made clear in the contingent right to purchase that if it's a sale subject to the buyer's the sale of their property, then that form should be used, and that's the contingent right to sale form should be used, and the buyer's notice of waiver removal of contingency should be used with Form 83. But the hour contingency is for every other type of contingency. And let's say it's subject to the buyer's ability to get a gift loan or something like that. That would be the appropriate contingency that you would use section or form 052 for. The change that has been made is to add the same alternative 1, alternative 2 approach, and that's new only to the extent that it doesn't substantively change the transaction at all. It's still a contingency, but what it does is it makes it a little bit clearer and lines up with the alternative 1 and 2 approach of section of form 083, which is a contingent right to sale. And then again, under the comment section of this form, I've gone through and broken out step by step how to use this form. And for those of you using the form for the first time, you're encouraged then to review it. The occupancy after closing section 054 has not been significantly changed, but it's been changed in a couple of respects. One, we've added this provision just to make it more clear. At the top, it's in yellow in regards to the term when the agreement to occupy would terminate. And you'll notice that it says not to exceed 90 days. That's important because that's what the state law says. Because we're trying to avoid the application of the landlord-tenant law. If seller retains possession longer than 90 days, then all of a sudden the buyer, who is the owner of the property, becomes a landlord, and you don't want that. Now, query whether or not, if let's say the transaction, the seller retained possession for 120 days, whether or not that makes the landlord, or the buyer automatically the landlord from day one, or only from every day after the 90th day. And I can't give you an answer to that, but I'm going to assume the doomsday interpretation that if it's over 90 days, then by golly, the entire transaction is subject to the landlord-tenant law, which you do not want. Turning to the next page, you'll see what has been deleted. There's a portion that's been deleted, and that has to do, with the liquidated damage provision. And you'll see why later. Because what we realized was that we had actually two different issues. One is use the application of the security deposit, and then also what happens if the seller retains possession longer than the deadline. And so what we've done is address those separately. And in section 12 on insurance, this hasn't really been changed. We've just changed the text in order to come into compliance better with how it is that insurance brokers and agents actually underwrite these transactions, where the buyer is obligated here to maintain property and casualty insurance. It isn't substantively changed. It just requires, it is just couched in different terms, simply because that's how the insurance industry views it, particularly in regards to naming the buyer as a co-insured on the property in the event of liability. And then the seller holdover section has all been deleted. And then we've substituted the following: if seller fails or refuses to vacate the property, in addition to any other sums provided, that the buyer may withhold from the deposit an amount equal to the per diem charge payable to the buyer's lender for the principal, interest, taxes, and insurance. So that seller holdover deals with that. And then, of course, if in fact the seller does hold over, then the buyer is entitled to go into FED court and have them evicted. And having them evicted does not eliminate any liability exposure that the seller still has. To put another way, you can evict the seller, and you can also go after the seller for damages. although the dispute resolution provisions of the sale agreement apply, which means that if you were going to seek a claim against the seller and it was under $10,000, it would still be in small claims court. And then the new section here about Section 15, delivery of keys, that's fairly self-explanatory. I think that is, I think we're pretty much at an end. Do we have any questions? Yeah. Okay. Yeah, John. If there is a question or a concern, or you would like a clarification, you can either call Lance on his phone number, which I know you have, or you can just type it in. I think you've been privy to on the Forms Committee to these changes, and so if you think there's a correction that needs to be made or something, I want to encourage you to, let us know. The one document that I mentioned that you do not have that relates to the seller carried nature of these transactions is that decision flow chart, and you can get that on ORAF online, and that's a very useful tool because it covers in one page essentially the vetting process to determine whether or not the seller is exempt from the mortgage licensing law, which essentially says that if you offer or negotiate the terms of a loan for a 1 to 4 family dwelling, that you've got to have an MLO license unless you're exempted. So I would say in 95% of the transactions there is going to be an exemption. You just want to be safe that in fact you vetted that, because you don't want a situation where somebody becomes liable under the MLO law. And in the materials I said also that it's important to keep things simple in these seller carry transactions. In other words, you want to avoid the use of in fact, there are some provisions just plain illegal. For example, negative amortization is illegal. A high interest rate of a loan would also be illegal. Both of those would trigger the MLO law and require that the licensee, require that the seller use a mortgage loan originator. So it's important that if your client, the seller, wants to get fancy and have some unusual provisions that we would consider not customary in today's marketplace, then you probably would be better off recommending that they use an attorney or a mortgage loan originator than getting involved in a transaction that could be rescinded or terminated by that buyer, and that is a consequence of improperly following the MLO law and not being licensed and putting onerous or burdensome terms into the transaction. Very, very important. The consequence, for example, on using a high interest rate loan, the consequence is that I think it's within 24 months, don't hold me to this, but it's 24 months, that the buyer can cancel the transaction and get all of their interest back. And so that's the consequence. It's a pretty heavy one. So you want to make sure that your client, if they're going to do something like that as a seller, in fact has vetted that with their own attorney. I think we've got a couple of minutes. Is there anything out there that I need to see? Okay. Yeah. If any of you have an issue, you can certainly email Orf, and Orf will get it to me, and we will get back with you. We've been doing this for some time now. Jeff has oftentimes helped me, Jeff Wyron, and responds, but we'll make sure that we'll get back if you have any emails. So with that, thank you very much, and let's see. Oh yeah, thanks to the COIR staff. Wendy Atkinson, by the way. Hi, Wendy. And also John Hoops. Best in 2016. Thank you very much.